Okay, we are not live. Okay, we're live. Snotty, you're the host though.
Oh, that we were showing our. All
Go ahead.
right. So, good evening, good afternoon, good morning, wherever you are around the world, and welcome to Focus on Liberia Next Gen. My name is Sonarti Raquel Yiria, and I'm your host. Along with me is Anthony Russell Jr. and Sam Ploquia Collins Jr., and we are Next Gen Liberia. Today's topic of discussion will be going into a deep dive of insight at the roundtable. Our topic is the rule of law, free speech, and institutional accountability. Our core objective here is to examine how Liberia's justice system interprets and enforces the law, particularly regarding free speech, due process, and judicial authority, using the Justin Opa Yazian, better yet known as Prophet Key case, as a focal point. Today, we'll be discussing and talking about national responsibility, setting the tone, the rule of law. Essentially, what that means is nobody is above the law. The law applies to everyone equally, especially including institutions, not individuals, who are met with the obligatory responsibility to guide justice. So tonight's discussion isn't about, ladies and gentlemen, attacking anyone. It isn't about debating religion. It's about understanding how Liberia's justice system works and what rights citizens actually have. And none other to lead us we have tonight is Attorney Freeman, Wonder Freeman, that joining us today, a Liberian attorney, accountant, economist, and certified financial crime specialist. Having grown up in Liberia, he brings both personal experience and professional insight into the socio-economic governance challenges facing the nation. His work is deeply rooted in advancing the rule of law, strengthening institutions, and promoting economic justice as key foundations for Liberia's long term development and prosperity. He's dedicated his career to studying Liberia's political economy and the critical issues of governance, accountability, and reform. Attorney Freeman, welcome. We celebrate you.
Thank you very much, Snotty. I'm happy to be here whenever we are talking about law and governance. It's always a nice time to be around.
Thank you. So let's go ahead and kick it off. Attorney Freeman, from a legal and institutional standpoint, why is strengthening the rule of law so central to Liberia's economic future?
Well, a lot of things pivots around the rule of law. Firstly, peace and stability. Secondly, economic growth and development. They all center around the rule of law. And without a rule of law, you will have problem with first peace and stability, and second, you will have problem with development and prosperity. So it is essential that if any group of people, look forward to development and prosperity, the first step is to establish a governance system and a rule of law that everybody can feel comfortable with, and that people can be able to know that if they pursue their individual projects, they can do so without maybe somebody cheating them or somebody robbing them or stuff like that. So it's very cardinal to it.
Thank you. Anthony Russ, over to you.
It's the audio.
Yeah, sorry. Okay. Yeah, let's get into discussing and understanding the law. First, let's talk about the foundation. Before we discuss any case, the audience must understand the legal framework. So, my question for you is, what does the rule of law actually mean within the Liberian constitutional system?
Well, it depends on what you're looking at. Um, because basically two aspects to the rule of law. One is the substantive law, and two is the procedural law. And in both instances, both have to work together in order for you to say that the law, or has been established or the law has been followed. And by substantive law, what we mean is that the law says what should be done or what shouldn't be done. It can be maybe in the form of a criminal law, like say, okay, you shouldn't assault somebody or stuff like that. Or it may be like a civil law where maybe there is some prohibition against you, maybe defaming somebody or something like that. So that's why it would say substantively. And then another aspect of the law sometimes is overlooked, but it's the procedure. So the law lay out how you can achieve a particular, maybe established goal legally. So in order for you to achieve the objective, you have to follow the adequate procedure. For example, if somebody maybe violate my civil rights, I should file a petition to the civil law court, for example, and that person will be given like 10 days to answer to whatever complaint I filed, and I will have another 10 days to respond to whatever answer they may have given. So those procedures that are laid out are both laid out under civil law and under criminal procedure. So when we talk about the law, we talk about the substantive law, and we also talk about the procedure. You cannot achieve one without the other. Like you can say, okay, since we achieve the substantive law, so the procedure is not that important. Or say, since we follow the procedure, the substantive law is not that important. For example, if the law says that maybe somebody having 1 kilogram of weed is a crime, if somebody has 1 gram, then that doesn't constitute a crime. So you can say, okay, maybe I followed the procedure to check them. I checked them and I found the weed on them. But the fact is, the law says it should be 1 kilogram, not 1 gram. So that would be the substantive law. And the process that you will use to pursue that law is the procedural law. A combination of those two will give you the rule of law.
Thank you. Sam?
That's I appreciate that. Thanks for clarifying that. Can you talk to me about protections that the Liberian Constitution provides regarding due process? You know, you laid it out fine, but as far as the Constitution is concerned, what does that look like as far as protecting or ensuring that due process happens?
Well, under Liberian law, especially the Constitution, Article 20 and Article 21 lays out the due process of law. And what that entails is that, firstly, with regards to criminal law, but that can be extended also to civil law, people have to receive a notice of whatever they are charged with. They have to be informed. They have to be given the rights to a lawyer. If there is to be an investigation, there is a right for them to have a lawyer at every aspects of the investigation. So the police cannot say, for example, that we are still investigating. It's not time for lawyers yet. Let the lawyers wait outside there. When we're ready, we'll call them in. No, that would be a denial of the due process of law. Also, too, the due process of law entails that there must be a forum with the competent jurisdiction. So what that means is, if it is a tax court, then you can take a marriage case to the tax court, because the tax court will not have the competent jurisdiction over marriage issues. And if it is like a commercial court, then you can take a criminal case to a commercial court because it will lack competent jurisdiction. So you have to go to a court, firstly with the competent jurisdiction, and the person who is presiding must also not have a conflict of interest. If the person is a party to the case, that person also cannot preside over the case. So that will fall afoul of the due process of law. One other cardinal aspect of due process of law is the burden of proof. So they are like different way they describe it. Some say beyond all reasonable doubt, which is very popular, which a lot of people know. That's in criminal law. But in the civil proceedings, we call that the preponderance of the evidence, or on the balance of probabilities. So with the civil litigation, they're just trying to know what is more likely. And so if this is more likely, then they could decide in your favor. Or in the criminal litigation, that is more demanding because obviously you have to prove beyond all reasonable doubt. So those standards have to be applicable if you are, for example, in a criminal case, you can't prove your case using the proof standards required under civil law. So that would be insufficient. The other aspect of due process is the right to a lawyer. And the right to a lawyer is not just you just give the person a lawyer and that's it. First, it's more likely has to involve the rights of to a lawyer of your choosing. So they cannot force a lawyer on you that you do not want. And two, the lawyer needs to be given like adequate time to study the case and to be able to present a defense in your favor. So one other aspect of the due process of law, which I think we rather stress on, there's many aspects, but let me just end on this note, is the right to appeal. So this right to appeal, whether you are running an individual, like a personal organization, maybe like NextGen, or you are running maybe the Freeport of Liberia, or you're running the police, whatever institution you are running, when you make a decision in the first instance, like the first time you do the investigation, there must always be a second instance where that person will exercise the right to appeal. The reason is simple. So if God is presiding over the case, there will be no need to appeal because God is perfect and God doesn't make a mistake. But if a human being is presiding over a case, there is always that potential that there could be an error. So the law is saying in order for due process to be exercised, there must be in any legal process an inherent appeal right to be exercised so that somebody presides over the case initially, and then at some point, if it's necessary, another person who was not affiliated with the case from below can review the instance and say, okay, I approve this, or I disapprove this, or I modify this, stuff like that. So maybe in the case of if you're running a private institution, maybe if you're human rights, not human rights, but human resource people investigate and say somebody should be dismissed, for example, there should be some kind of appeal process that they can appeal to in the organization so that another person can look at it and see whether everything was done correctly, and if it was not done, they can correct it. So those are fundamental aspects of due process of law, but due process have other dimensions, maybe based on how the discussion goes. Some of those may crop up and we'll clarify.
Sure, rightly said. So, Attorney Freeman, we understand that a strong country depends on the three pillars of justice, essentially the rule of law, the due process, as you spoke to, and the third, which is judicial independence. Courts must make decisions based on law, not politics, not pressure, and not public opinion. So, what powers, Attorney Freeman, does the Supreme Court have, and what limits exist on the Chief Justice authority?
With the Supreme Court, I guess the limit are first constitutional, because, for example, the Constitution says that no branch may exercise the power reserved for another branch. So if the Supreme Court makes a decision, for example, it cannot enforce that decision. The enforcement of that decision is left with the executive. Also, too, if the court makes a decision, the legislature can override that decision by passing a new law. So by passing a new law, they can nullify the decision of the court. The other limitation of the court is that the court is not supposed to interpret the law in such a way as to make a new law. Like, for example, what do we mean? If the punishment for a specific crime says you should go to jail for like 3 months, the court cannot send you to jail for 1 year, because sending you to jail for 1 year will amount to the court making law. And the Constitution forbids that the court should make law, because the court is only supposed to interpret. So let's say maybe there is a particular felony, and they say, okay, this person is supposed to be fined maybe $1,000. But the person really did bad, really wicked thing the person did, and the judge is angry. And the judge really want to punish the person. But on the book, it says fine this person $1,000. Well, the judge cannot fine the person $10,000 or $100,000, because to do so would be to make law. The judge must fine that person only what is written in the law. The judge cannot go beyond that, because that right to go beyond that is reserved to the national legislature. Only the legislature can come back and say, oh, we realize that in case John Brown, he did real bad things, and so the $1,000 fine was not enough. So we are passing a new law to make the fine $50,000 or to make the fine $100,000. But under no circumstance can the court decide on their own that even though the punishment is $1,000, but this crime is too bad, so we will make it $10,000 or we'll make it $100,000. If you did that at the lower court, let's say you did that at the magisterial court, if there is an appeal, a circuit court judge can reverse that ruling on ground that you're supposed to stick to whatever punishment is written down in the law. You can't go above that. And if you did it at the circuit court, the Supreme Court can reverse that on the same condition, that you can't go beyond what is stated in the statute. So unfortunately, if you have a Supreme Court going above what the statute says, then I don't know. Well, I guess this is Liberia, you know.
I was just about to ask, so is this subjective?
Well, in a sense, yeah, because you mentioned the perfect key thing. And I mean, in the statute, the judiciary or law, you know, I forgot the specific article, but it's clearly stated that the punishment for contempt, criminal contempt, is a maximum of 30 days in jail. And the Supreme Court decided to sentence him because they felt he did really, really bad things, so they should sentence him to 180 days. That amounts to making law. And that is a violation of the Constitution, because the court is not supposed to make law. Okay? Because, I mean, come to think of it, you may not be a lawyer, but if the law on the book says, punish this man for 10 days, and every judge can decide, no, you really did bad, so I want to make it 100 days, or I want to make it 200 days, or I want to make it 500, then there is no law. Then, I mean, your punishment just depends on whoever judge you are before him. And if that judge is really angry, he could make it 1,000 days. So the court cannot go beyond what is in the statute. There are some laws that give the court discretion. If they give them discretion, fine. But if the statute says this number of days, you cannot go beyond that number of days. That will be making law, and making law is reserved only to the national legislature.
Sure. Thank you so much. And that leads us right into our next segment. I'm glad that you brought that up. We want to help youth understand, Attorney Freeman, that this issue, it didn't just start today. You know, we're discussing past controversies involving free speech. Anthony Russell, please, over to you as we dive deep into free speech.
Yeah, as my host was saying, the question here stands: what does the Constitution of Liberia states about freedom of speech, and where does freedom of speech actually ends and criminality liability begins?
What is? Can you go back over the question again?
What is the Liberian Constitution saying about freedom of speech, and where does freedom of speech ends, and where does criminality actually begins?
Okay, so the Liberian Constitution actually grants every Liberian the right to free speech or being fully liable for whatever damage that your exercise of that right, causes. So back in the days, there were statutes that criminalized certain speech for what we call criminal defamation. It could be a libel, or it could be slander. Well, slander is, when you say something by word of mouth, or that is defamatory, and libel is when you say you write something that is defamatory. Okay, but then that law was revised under pressure from the press union, under what they term as the Camara free speech law. So, meaning as of the passage of that law, nobody can be penalized under a criminal proceedings for speech. So you can be penalized, but it has to be a civil proceeding. So you need to understand that statutes in the republic, and by statute, what we mean is the law that has been passed by the national legislature. So a statute is an extension of the Constitution, because when the Constitution was passed, it granted the legislature the right to make other laws necessary for the governance of Liberia. So by granting the national legislature the right to make other laws, and when they make other law, is an extension of the Constitution, and it is presumed to be constitutional until it can go to court, and the court can strike down that particular law. And even if the court does so, the court may strike down only that line or that paragraph that it considers unconstitutional. For example, if a particular statute made by the legislature has 99 articles, and you go to court and we learn that maybe one article is under controversy, it goes to the court, and the court say that law is unconstitutional, where the court is actually saying that one article in that statute is unconstitutional, not the entire statute. Just that if there's a line, then that line is unconstitutional. If it's a paragraph, then that paragraph is unconstitutional, not the entire statute. So when the legislature passes a law, that law is presumed to be constitutional until it can go to the Supreme Court, and the Supreme Court can strike it down and say it's unconstitutional. So the law, for example, the Kekula A. Camara, statute against criminal slander or criminal defamation is constitutional unless it can go to court and the court can say it's unconstitutional. So meaning all the courts and should recognize that law. So that's where but also too, people can be held for defamation arising from slander or arising from libel. So by and under a criminal statute generally, it is not like, for example, if I give an opinion cannot be a criminal. For example, if I say you are a liar, or maybe you are dishonest, I mean, why? It's just my opinion. It doesn't mean anything. I have to accuse you of committing some act that is considered a crime under the law for it to have weight. For example, if I say that maybe you're a manager somewhere and I say that you mismanage or you embezzle X amount of dollars from the institution, stuff like that. So embezzlement is a crime under Liberian law. So if I accuse you of doing that, then the issue of damages will hold. But to say you ugly or you arrogant or you stupid or you dumb, I mean, none of that constitutes just opinion. None of that constitutes what we call a basis for an action under the law. Yeah, it must be that I accuse you of an act that has been defined under Liberian law to be criminal. But it's not you arrogant, you dumb, you stupid, you know nothing. What's that? It means nothing. It's just you expressing your opinion. That's it. So the limitation on free speech, as far as I know, is limited to the liability associated with the limits on free speech is by way of a suit for defamation. So if you defame somebody's character and then they can pursue you, but it will be a civil procedure because, like I said, the legislature has already passed a law doing away with criminal penalties for slander, for libel, for defamation. So the only means now is a civil procedure. And by civil procedure, what we mean is that you can be fined and other civil remedies, like you can be asked to retract, you can be fined, but you cannot go to jail for that purpose. That's the idea of removing a criminal libel. And the reason is that, because law is based on reason. The reason is that when you take a public office, generally, the assumption is that you are expected to go under a fair amount of criticism. And so it is not expected that you go around suing every press person, right? So for that thing to hold against a press person or somebody making a statement, they really have to show that they're dealing with what we call malicious intent. Malicious intent. That means they know it was wrong. They have every reason to have been warned that it was wrong. And for some reason, they decided, notwithstanding the fact that they know that it's wrong, they still went ahead and did it. If they did it by mistake, then the law can't necessarily hold them, for that. Especially for people like journalists and other people, who are in the public domain. It really has to be like a malicious intent. That's why sometimes when you find somebody saying something that you find defamatory, the first step is not necessarily to sue. The first step is to write them a cease and desist letter. Because the cease and desist will put them on notice that what you are doing, maybe you didn't know before that it was false and misleading, but I'm telling you now that it's false and misleading. So stop. And then often, sometimes, if the person decides to go ahead, now we're sending the notice that they should cease and desist, then you can go ahead and sue them, on whichever procedure you choose to pursue. But yeah, those are the limitations on free speech. May I also add that free speech includes the right to insult people. I know it may be controversial, but free speech, if it were not the right to insult people, there will be no need for free speech. The free speech is the right to say something that is annoying to another person. Okay, that's why it's protected. Yeah, subject to whatever limitations in the Constitution and under law. So if somebody can say that you use derogatory language, and so because of I can tell somebody that they are a buffoon and they are a nincompoop. That is my right to tell you my opinion about how I feel about you. I mean, it's nothing, So the right is, if it was just the right to say praise the Lord, amen, brother, you are blessed, there'll be no need to protect it. The protection is because we know that people will be offended, but we are telling you, irrespective of your offense, this speech is protected. That's the idea of protection. The protection is not to protect good language. It is not to protect nice language. The protection is to protect language that other people will find offensive. But the way that we go about establishing the truth is that in the exchange of ideas, whether offensive or not, we will arrive at the truth. That's why that speech is protected. So let nobody fool you that the right to speech only means to tell people, brother, you are blessed, or sister, you are blessed. Go in peace. May the Lord bless you. No, it includes the right to tell somebody that they are a buffoon, they are an idiot, they are stupid.
Amen.
Yeah.
I love
Yes,
it.
there will be no need to protect it because, I mean, what's the point? If you tell me I'm blessed, we ask you for it.
I love it.
No, so the
Yeah.
protection is because of that. That, yeah, they will tell you something that is offensive, but as long as this person is not accusing you of committing a crime or anything like that, forget it. There is not much you can do about it.
Sure.
Yeah. Man, thank you. You really knocking it out as expected. Can you talk to us about what legally qualifies as contempt, and under what circumstances would speech become contempt?
Okay, so there are two types of contempt. Like I said, the law is generally split between criminal and civil. So you can break it up further, but the two general approaches to understanding the law is civil or criminal. I guess everybody knows what criminal is. So, okay. So now, if the court makes a decision, or let's say maybe somebody took away somebody's property and the court say, bring that property back. And the person who is in illegal possession of the property decides to hide the property so that the court may not take possession of the property. The court can bring you in for contempt, meaning we are trying to pursue justice and we're trying to retrieve this property from your illegal possession, and you are hiding this property so we can hold you for contempt. And by saying the court, it doesn't have to be the judges, even the messengers from the court, like the sheriff and other people, and they go out in the field to do the work, and you try to undermine it, they can hold you for contempt. The other thing is, let's say the court is in the process of carrying on a court case or making a trial, and you do something to disrupt the trial or bring the court into disrepute, then they can hold you for contempt. If you say something that affects the way the court administers justice and stuff like that, the court can also hold you for contempt. But it has to be either a matter that is heading to the court, at the court, or leaving the court. Recall, the court is at the center of it. At the court, let's say heading to the court, you interfere. At the court, you interfere. Leaving the court, you interfere. Insulting a judge is not a basis for contempt if it's not tied to a court case pending before the court. Like, say, you have a problem with one of the judges, maybe you got land problem, and you get there and you say that judge is a crook, and stuff like that. Like you just flare up. And that's a personal matter between one Liberian citizen and another Liberian citizen. Is it tied to a matter heading to court? At the court? Leaving the court? No. So the court cannot exercise contempt. The thing about contempt is that it's a broad power given to the court. And the court is the main judge on how to use the power. So like in any human tendency. There is a tendency to abuse the power because, of course, they get to say what constitutes contempt, so they can stretch the definition of contempt. But contempt is a very heavy power. I like to compare it frequently with the power of the president to pardon, because you cannot question the power of the president to pardon. So because of that, the president cannot just go about pardoning anybody. As soon as somebody commit crime, you just pardon. You have to use that pardon power wisely and under, very germane circumstances. So it's the same way with the contempt power, because it's an extraordinary power of the court. It is not a power anytime somebody made you angry, you just call them and say, well, I have the power to hold you in contempt. So I will bring you now, say you have land problem, and the last time we went on that land, you insulted me. So, well, I don't like the way you insulted me, but I will not say anything. When I go to court Monday morning, I will send for you and I'll bring you to the court and I'll hold you in contempt. No. That thing must be tied to some court case or something going on at the court. It cannot be that you and myself have a land problem and then you bring me to the court and then you hold me in contempt. I think if they do that, they may do it, but I think that would be an abuse of the contempt or power.
Awesome. Thank you so much. Oh, did you have anything to say, Russ?
Oh, no, I was just calling you to go ahead.
Oh, awesome. So thank you so much for that, Attorney Freeman. Ladies and gentlemen, just wanted to go ahead and do a quick recap. This is Focus on Liberia Next Gen. Please, if you're watching, feel free to share, like, comment, subscribe, share this information with your brother, sister, youth. They need to be in the chat. They need to be engaged. They need to be aware of our topic of discussion. We're talking about the rule of law, free speech, and institutional accountability. Now, let's talk about free speech. We're moving from theory, right, to real-world legal interpretation. So our question for you, Attorney Freeman, as we move on to the specific case with none other than Justin Olpa-Yezin, better yet known as Prophet Key, what were the formal legal charges in the Prophet Key case? Let's talk about it.
It didn't arise from a formal case per se, because the Chief Justice just issued a citation and said he should come and show cause why he shouldn't be held in contempt, because he, I understand, insulted the Chief Justice. And normally, we used to see cases like originate at the lower courts, but this is a contempt case, like I said. The Chief Justice, in his wisdom, decided that his insults amounted to contempt. But like I said, I differ with the court, because I really feel that if this thing has something to do with a situation at the court, heading to the court, at the court, leaving the court, that would make more sense to me. But somebody just gets on his platform, Facebook. First thing, on a Facebook platform, you have to go on his platform to listen to it, right? I mean, yeah, you have to be his friend, or you have to go there and listen to it. So if you're not invited, why carry you there in the first place to listen to it? Secondly, I feel like it is a backward, because, like I said, the national legislature has already decriminalized speech, offensive speech, or whatever you call it, criminal libel or criminal slander. So you cannot now pass it around and say, okay, somebody says something, I need to put it in jail, so let me use the contempt power, saying that law is not rectified. Secondly, the law should be applicable to everyone, not just, you don't have a special law for the justices on the Supreme Court and then a special law for everybody else. So what he did, Are we now going to arrest other people in Liberia? Let's say two women, and one person get on a Facebook platform and insult the other woman very badly in the worst possible way. Will the other person now be arrested? Or will the arrest only occur because you directed that course at setting justice? Unless you tell me there are two different types of law. One for the judges on the Supreme Court and one for the average citizen. But if two persons making confusion and one person can get on the Facebook platform and insult the other person and that person cannot be arrested, I don't see any reason why it's going to be applicable to a justice. You have to understand that when the court makes a decision, that judgment, that decision is law. So right now, as we speak, that's the new law in the country. That if you get on your Facebook page, I know a lot of people do it every day. They insult other people that they don't like, or somebody they're having a beef with, they insult them. And by and large, the police is not going to come after you because the police will think that it's a private matter. And that's, but now what the court is saying that no, it's not a private matter, it's a crime. You cannot go around insulting people. But you know the reason why the court don't pass those kinds of law is because how are you going to enforce it? Everybody has smartphones sitting down on top of the toilet and insulting other people. Or everybody somewhere in the market drinking a king juice, they go on, they take their smartphone and they put their phone on and they insult another person. You can't enforce a law like that. So the law tries to avoid a situation where they will make a law that you can't enforce. So this law, it looks to me like the only way it can be enforced is that you direct your insult out of justice. But if I say, oh, Tony, and I rain insult down upon you, if you go to the police now, the police will not do anything for you. The police will not do anything for you because the police will feel that it's a waste of their time. I mean, what happened? The man cost you, so I cost the man back. So by the court passing a law like that, the court is saying that it's a crime. But now it seems like it only works when you are directing nothing against a judge. And there shouldn't be two laws in the country. There's only one law. And that law is applicable to everybody across the board. That is why the court is not supposed to pass a law that seems to be only enforceable when it is directed at people on the court. But when two ordinary Liberians doing it, then it's not a crime. No, if it's something is a crime, it's a crime for everybody. It can be a crime because this guy did it to a judge. But if he did it to Julie Andy, then well, no, it's not a crime. You know, if he did it to any other person, it's not a crime. But it becomes a crime because well, he decided to do it to the Chief Justice. No, if it is a crime, it has to be a crime for everybody. It can be a crime for only the justices on the Supreme Court. And that is why I feel that they were in error to pass such a law.
So
Sure.
let's talk more about, you know, the due process concerning this case. I think based on the known facts of this situation, was this ruling consistent with constitutional due process?
I also disagree with the court on a number of grounds. Ground number one, they brought him to the court and he said he didn't have a lawyer. And then the court gave him a lawyer and he said, I think come back tomorrow or come back the after tomorrow.
Yeah.
I disagree with that because that come back tomorrow or come back the after tomorrow is insufficient timing for you to defend a client at the Supreme Court level. I feel that maybe 10 days, maybe 2 weeks, maybe 1 month will be sufficient time for a lawyer to put a constitutional argument together to go to the court. I don't believe that at the Supreme Court level, somebody can, 24 hours or 48 hours is enough time to mount a defense. So on that ground, I disagree with the court. The second ground I disagree with them is when they appointed the lawyers didn't mount any argument on behalf of Prophet Key. That is professional malpractice. Okay, that's malpractice. If you don't want to be a lawyer for a client, you withdraw. But you can't like take a client case and then you go to court and you don't put up not a single argument on behalf of the. Then why make you a lawyer? Well, what's the point in being a lawyer if you're not going to go to court, and even pretend to argue for the client? They didn't even pretend. They just went there and told him, he needs to apologize. I don't have a problem with apologizing, but put my argument on the table first. If the court reject my argument and they want to punish me, I will apologize, but put my argument on the table. But they didn't put any argument on the table for him. The other thing that I want to disagree with the court is the participation of Justice Bessie, because Justice Bessie was the one who lodged the complaint.
Yes.
And they may push it around, they may say the court, but if you listen to the statement that he was accused of saying, he singled out Justice Bessie and called him corrupt, and then accused him of being corrupt, and then mentioned his hotel. So he was really specific about Justice Bessie, and that court went to court because Justice Bessie filed a complaint. So I felt like the least he could have done was to recuse himself from the case. This is more than 2,000 years of legal principle that you cannot be a judge and be a complainant at the same time. More than 2,000 years in human history, we don't do that. Okay? When you are the complainant or you are the victim, you can't be the judge, because obviously it's obvious there's only one way the case will end if you're a complainant and then you're the judge. So I disagree with the court on that ground, and that is fundamental to the due process of law, that the tribunal that is presiding must be impartial. It must be free from conflict of interest. Okay, but by say participation in that case, or where he was substantially the complainant and the judge, I think that was contrary to the due process rights of Prophet Key. The other problem I see there is the denial of the right to appeal, because by starting the court, like there's such a case in the Supreme Court, at the end of the day, there is no appeal for him, because you can't appeal from the Supreme Court. So, in a way, I mean, he was cooked. Once they declare him liable, he was cooked. Or once they declare him guilty, since this is a criminal matter, once they declare him guilty, he was cooked. But if you look in the Constitution, the right to appeal is enshrined in the Constitution, that in any proceeding, the right to appeal must be preserved. So it was important for them to have like maybe started that case, as a civil matter under the circuit level, because the other aspect that I disagree with them too is that this guy was alleging, even though he apologized and he sort of took on responsibility, but let's assume if he didn't apologize, what he was alleging some factual issues that can only be confirmed if there were evidence, for example, and that is another key part of due process. In fact, that is, if I will say, the number one issue when it comes to due process, it has to do with the ability to present evidence in your favor and the ability to confront evidence against you. Those two things must be part and parcel of any litigation process, any legal process. It doesn't even have to be a straight up litigation, any kind of hearing, investigation, any way you want to describe it. You must give the person that you are accusing an opportunity to present evidence on their behalf. And you must give them an opportunity to confront evidence against them. So if you call a guy and say, oh, I heard you insulted me, you said a lot of lies about me, then you must give me an opportunity, to present his evidence on his behalf. But because the Supreme Court is designed in a way that they don't take evidence, so that procedure will not have been a ideal venue for him to present evidence on his behalf. And if there were evidence against him, it was no way he could cross-examine the evidence against him. You see? So if you look in Article 20 and 21 of the Liberian Constitution, those are fundamental rights that you can't dispense with. Think about it, right? It's nothing, they accuse you of doing something, and then when you want to talk, they say, oh, no, it's nothing, you can't talk because this case is against your power. So you can't give evidence because the man is a big man and he older than you 2 times, 3 times, so you got to shut up. And, and the big man will talk, and after that, they will end the case.
God forbid.
So you see, some of these things, it may look legal, but under the law, there's a lot of common sense. Yeah, so they cannot say brings nothing here. We allege that she did A, B, C, and D. Then somebody say, okay, let me talk. They say, no, shut up. You can't talk against your man. The person is 2, 3 times older than you. So wait. Then your man presented evidence. Then everybody else talk. And they say, but you can't talk because in this place here, all the people that here like that, your auntie and uncle, they are older than you. So you can't say anything. Okay? So maybe in a family setting, that may be fine. But in a government setting, everybody, small, big, black, white, rude, not rude, everybody is entitled to present evidence in their favor and to confront the evidence against them. The second part of it is even more important than the first one. The opportunity to confront. When somebody says you stole, you must be able to ask them why I stole, when, where, how did you know, how much. If you are not able to do that, then that will be a denial of your right to confront evidence against you. It will be a denial of your constitutional right. So by then starting the case in the Supreme Court, knowing very well that this case you will not be able to take, because for example, the man alleged that this guy is doing business and he's judged and the judicial, or court prevents him. So he was saying some things that you can only establish by either bringing evidence or confronting evidence. But that doesn't happen in the Supreme Court because the Supreme Court is generally for appeals. Okay, maybe if a county is a party to the case, it can start there, and I think diplomats and some minister, but just at that level, almost everything has to start below. So not being able to bring evidence on his behalf or to confront evidence against him was bad, but then obviously the lawyer just told him go there and accept responsibility. So he also didn't exercise his right, and that's what I'm saying, that the lawyer did professional malpractice, because had they put forward some of these things I'm talking, don't you think they should have just put some of this argument forward? They could have just done that on his behalf. I mean, what's the point in being somebody's lawyer if you will not say anything on their behalf? It was just very bad what it did to him. I mean, it was just very, very bad what it did to him. Look, let people understand this thing. It doesn't matter. The law doesn't say, oh, when they're obedient children, they will protect. It protect rude people.
Right.
It protect quiet director. It protect rude people. It protect prostitute. It protect anybody alone is not breaking the law protects you. So they could have put up at least 2, 3 arguments for him. They put nothing up. That is not a definition of a lawyer, to go to court and make absolutely no argument for your client.
Absolutely. Should I say weaponry at its finest? Anthony Russell, do you have anything else to weigh in on it?
Not specifically. We can pass this off to Sam to, if Sam has any other questions. Yeah.
I actually wanted to get into free speech, look at it more historically, if that was fine. I'm speaking as a journalist. I'm very interested in getting your take on, the patterns as far as case law. Do you see a pattern as far as how Liberia handles free speech disputes? And we're talking about, with the Spoon Network closure back in 23, the Octavian Williams detention situation back during Ma Ellen's time, and then even with the PUL versus the government back in 2015. Is there a pattern that we're seeing here? Can you just explore that for us?
Well, case law, I will have to be more specific, but those are not cases that I'm fully familiar with, like how they ended, because mostly if the case didn't go to the Supreme Court and for the Supreme Court to issue a ruling, generally it's not yet law.
Got you.
The law is established when it goes to the Supreme Court. That's what I'm saying right now. The law in Liberia is that if you get on Facebook and you insult another person, you can be arrested and you can be prosecuted. So all the people out there, you gotta be careful what you say on social media, whether it's Instagram or whatever, because that's the new law now. Unless they are telling me that law is only applicable to judges, But if you make a decision, it goes across. But the other point I want to say, especially in the Prophet Key situation, is the prohibition against cruel and unusual punishment. So the Constitution prohibits cruel and unusual punishment. Growing up, they had a story in the Bible about Daniel in the lion den, right? Where I think the lion did something and the king didn't like it and say you're throwing in the lion den. Okay, so now these modern days, you can't, let's say, keep maybe an alligator water, right? And if somebody commit a crime, let's say they did a really bad crime, and you say, okay, but that crime is too bad, it's so bad, you throw him in the alligator water. You can't have a punishment like that. Okay, so you can't have a cruel punishment or you can't have an unusual punishment. Okay, so in my mind, if the law says punish this man for 30 days, let him go to jail for 30 days. To punish him for 180 days, man, not 45, not 60, but 30 times how much we give you 180?
So I guess, like, with that being said, do you see these civil defamation laws being used to silence critics?
No, what you tell me, because I'm talking about cruel and unusual. If the law say, let's just say the law say give the man 30 lashes, and you jump over the 30 and you give him 180 lashes, maybe he would die. I mean, I'm just looking at it from the point of view of lashes now. If you're supposed to give somebody 30 lashes and you say, well, the guy been too rude for a long time, so instead of giving him 30, let me give him 180. That would be unusual. In my mind, that would even be cruel.
Definitely.
So, yeah, so the Constitution prohibits cruel and unusual punishment. So trying to punish somebody for 180 days when they're supposed to take a 30-day punishment, I think that is not right. Whether you're looking at it from the point of view of ethics or you're looking at it from the point of view of law. That's why the law says if there is a punishment on the book, you cannot go above.
So my question to you is, after 30 days, if Perfect Key, if anything dangerous, like health wise, were to happen to him, will the Supreme Court, the Supreme Justice, be held accountable for that?
I think so, but then I would find it useless for you to go to court, because the same people who punish you, if you go back and say, take responsibility for what you did, obviously they're not going to do it. But it is unusual to multiply the punishment by 6, because that's what they did. Yes, the law said 30 days imprisonment, and then you say 30 days too small because he really, really did bad things. So I got to do it 30 times 6. The Constitution doesn't allow you to institute unusual punishment. Okay, so you can't keep a pit of cobra and say, but this guy, he committed a very, very bad crime, so you're throwing in a cobra pit. So it's the same, So I feel that what the justices did, it's not right, and people want to overlook it because, as far as the concerned, Prophet Key is rude, so he deserves it. But someday Prophet Key will not be in the picture, but that law will be used against another Liberian citizen. So people should be careful what they wish for, because right now it is a rude man, so he deserves it. But tomorrow it will extend. And if you follow the trend now, the legislature recently wanted to use contempt power to bring in the Minister of Justice, because according to them, there was an audit and the Minister of Justice wrote them and asked for additional information, and they said that he was disrespecting them, so they wanted to bring him in for contempt. So he had to apologize. Recently, the legislature, the speaker also sent for the finance minister and said, "You're bringing him, and if he refuses, you'll put him in jail or something like that," because according to them, he refused to give them their just salaries. So once the Supreme Court started to use contempt power in a way that is very expensive, of course, they're not the only people with power. The Senate also has power. They can also use their contempt power, and bring in people who are not rude, maybe people who didn't insult, but they're using their contempt powers. And if the Chief Justice and the Justices use their contempt power in certain way, how are they going to tell the other people you can't use your contempt power in that form and manner? So the speaker now sent for the finance minister and say, "You're bringing, if you don't bring, you're putting in jail," or something like that. And so you don't want to live in a country where everybody who feels they have some political power just expand it and use it in a manner and form that is inconsistent with what the constitutional framers thought about. So I really think that in a lot of ways, this case against Prophet Key, notwithstanding the fact that he used very foul language and other things, but I think he could be punished, but just follow the due process of law. Like I said, the law is twofold. They got a substantive law, and that way you say the person committed a crime, but they have the procedural law. That's where you must stick to legal procedures. You must use legal evidence. You must use a legal forum, and the punishment must be legal.
Thank you.
So if you can't use a wrong charge, then you go to the legal forum and you do a legal punishment. The wrong charge will be wrong. If you have the right charge, but you go to the wrong forum, it will be wrong. You can have the right charge, you can have the right forum. If you administer the wrong punishment, that would be wrong.
Right.
So the thing about due process, if you ever taken a test that is pass or fail, those kind of tests where you take is pass or fail, right? So you can't, due process doesn't allow you to say, okay, you score 40 or you score 50. Due process, you have to pass or you fail. So you can say, well, we gave him 10% of his due process, right? Or we gave him 40% or 50%. You have to give him all his right to due process. You can't leave one out, So that is the problem I have with him. But for now, he seemed to be like a pariah. He has offended a lot of people. People are very happy that he's gone to jail. But of course, people, it's not like he's the first person who ever caused before. I mean, people have been causing in Liberia since nothing. Even when he died today, tomorrow, another person who can't about it will still cause happy. So it's just part of life. So I don't know the idea of trying to choose somebody because at the end of the day, even if he died today, there will be another person who will cause, right? I don't want to believe that because Liberia was founded 1847. So from 1847, I don't want to believe he's the first person to cause. The only thing maybe because there's a social media, and so when he gets on the social media, it goes around the world. But I mean, it doesn't make any difference. People have been doing it, and even if he leaves the scene, people are going to do it. Imagine when we were in power. I mean, there was not only him. Yeke Kolba was causing we are every other day. Even Henry Costa that brought this government to power. Henry Costa was on the air insulting people throughout, and they too, they were utilizing Prophet Key when it was in their favor, as long as he was insulting their political opponent, it was fine. The only time he committed a crime when he decided to turn the insult to them. That's the definition of a banana republic. That's the definition of a banana republic. Where justice. That's it. The law is applicable based on who you are or who was affected or who was offended. That law is across the board. You can't be that when he was insulting Weah and when Yeka Koluba and other people were insulting Weah, it was lawful. But when he
Yeah.
switched around and started insulting the people who he put in power, then it becomes unlawful. That's not law. So I mean, they're just happy they got power, they are using it, but obviously they will leave from power and another group will come. You don't know what they will do.
So
Absolutely.
just
Go ahead.
to wrap up real quick, like given everything you said, to Russ's point, if it's the past 30 days, bringing Prophet Key back to the same court that took him in there, that's kind of futile, right? So what kind
Yeah,
of
yeah, yeah.
protections exist? With everything you said, what do we have as Liberians?
Okay, before I go to Liberia, I can say with the Prophet Key people, but I guess they have already apologized and they accepted they were wrong, so they don't have a
They're
lot to
guilty.
say.
Yeah.
But honestly, the first thing, if I were them, I would complain the lawyers to the bar
Mm.
because really that is malpractice. You cannot say you are going to represent a client and you don't put even one single argument on the table on behalf of the client. There's no point in being the person legal representative. Tell them you don't want to do it so they can find somebody who is willing to put up argument on their behalf. You can go to court and just say, my man, what happened, the way I see it, my man, the people. And the reason is that a lot of the judges, sometimes not judges, a lot of the counselors, sometimes they have other cases at the Supreme Court with big money. So sometimes they are hesitant to put up a robust defense because maybe you get a $500,000 case sitting down there. They have not decided it yet. So they say defending man, the men are foolish men. You always on air causing people. I'm not coming to jeopardize my $500,000 case, for the stupid man. So maybe that could be. But I think Liberian people should protect each other, even though, like for me, I'll be honest with you, I last listened to Prophet King maybe more than 5 years ago. Yeah. And I listened to him once or twice at that time, but it was just too rude. I just couldn't make it to continue listening to him because there was nothing concrete in me. But it was entertainment for some people. So some people listen to him. So I don't listen to him. But when it comes to the rule of law, you can't have two, three different type of rules. You have to have one rule, one law that applicable to everybody. The law has to protect everybody across the board. It
Right.
can't protect the judges, and then the same law that protect the judges, it can't protect other people, stuff like that. So Liberian people should speak out, even though they may not like the individual in question, but there is a high chance that once they work with the person who is considered rude, the next thing you look, it will start affecting those who may not necessarily be rude. Maybe the choir director will come in, or the church mother could be brought. Maybe she saw vision, she said something, and some judge is not happy. He said, okay, that vision you said you saw, and you told my wife that I had a girlfriend, you will come here and I will hold you in contempt. You know, what stop them? They could use the law in any way they want. So it's very important that people realize that you don't have to be nice or be polite or civil in order for the Constitution to protect you. The Constitution is supposed to protect everybody across the board. So that's much I can say.
Yeah, so we've been talking about the Prophet Keys situation for a while now. And we're kind of hinting towards selective justice and I would say the public perception. So what do you think, how does this ruling actually affect the public trust in the justice system? Is it something is it a selective
Well,
prioritization?
the public have not had a lot of confidence in the justice system to start with.
Why is that?
Uh, Because some of the what we call major cases has gone to court and the results coming from the court have been very discouraging.
Can you
For
give us?
example, there was $100,000 drug bust case that went to court.
Correct.
Yes. What was the result? They were found not guilty, right?
Yes.
There was another case with Jessica and her, I don't know, husband or whatever, and he tried to cut her throat, and the mark was left on her throat. They went to court, right?
Correct.
And he was also declared not guilty.
Not guilty.
Brandon Samoka stole more than $1 million from the AFS Sawyer.
Hmm.
Did he spend a single night in jail?
No.
No. The Supreme Court ruled that he should pay the money back. But that's not what they call criminal law. If you stole, you first have to go to jail. Then later on, we can pardon you, maybe give you probation. But he was the first in the court were the first people to say he should pay the money back. He shouldn't go to jail. That was also wrong, And then the president added up by granting him a commutation. Say, okay, don't go to jail, we lower your whatever. But so that encourages more. So the court has been making a lot of decisions that have caused the Liberian people to lose trust in them. And even this Prophet Key case, people are asking, so how come if the court system can work very fast, why is it not working very fast when the case has to do with the public interest? It seems to be working so fast when the judge is the complainant, but when the average Liberian person is the complainant, then the court is taking 4 or 5 years. People are asking that question. And it will not help by the court repeatedly using the contempt power to say, oh, okay, but if you say anything we don't like, we'll bring you here and we'll judge you, we'll put you. Look, there was a reason why the Civil War came to that country and more than 250,000 of our people died. I don't know who checked the people when they were dying, but that's the number that we use, right? Okay. Because Liberia was a country where people say, you know who I am. And now you know who I am. Time in, time out, the ordinary citizen could not get justice. And when you run a country for year in, year out, the ordinary people are going to get one fine day, somebody is going to get pissed and say, okay, I'm not even bothering to go to justice. I'm going to get my gun, and I'm going to go to this location. I'm going to administer justice myself. So it is very important for people not to take it lightly to say, oh man, it's just another rude guy that we put in jail. We don't need to worry ourselves about it. That where rude people belong. But the court is losing the confidence of the average citizen. And those are things that can happen when people no longer trust that they will get justice when they go to court. They may decide to administer justice on their own. And sometimes before they are arrested or before they are stopped, maybe somebody has died, maybe a building has been burned down, stuff like that. So people should not take it for granted to say, oh, this person, in fact, nobody liked them or this and that, so they're really not entitled to justice. The other people who can go to church every Sunday, well, we give them justice, but the other person is an atheist, so they can't get justice. You can't continue like that because someday somebody is going to say, okay, I'm not going to go to any court because it's a waste of my time. I will administer my own justice. And you know what happens when somebody decides I will administer my own justice? And even the innocent people can end up dying in the process. So that's why I think. So I don't think this decision helps the court to build confidence. What will build confidence is when people see justice is fast, not just because a judge complained, but because the citizen was harmed and the judges recognize that some wrong had been done. But right now, as I see, more people are of the belief that the case, the court system is capable of judging case fast when they want to. But they will not judge it fast if it has to do with the average citizen.
And I needed some clarity on that because currently we have a couple of rape cases with sodomization, as well as we know the multiple rape cases of young women, young girls, right? So can the Chief Justice prioritize those cases like he did with the Perfect Keys and move it up for a faster decision, or does I mean because this really
Well, he
shows.
can use contempt. He can use contempt power to do that.
Oh, okay.
So in that way, he can fast track it like that. But the real problem there is that we have a code called the Criminal Code E,
Right.
and that code has almost like exclusive jurisdiction over um, rape cases.
Rape cases.
But I
Right.
think the problem is that they have not decentralized Criminal Code E.
Mm.
So by having it only at the Temple of Justice,
What justice? Right. Uh-huh.
it means that from the 15 counties, they probably are transferring.
All of the cases over there.
Yeah, so that could be a problem. I guess if they were to like authorize all the circuit courts, I'm not sure whether that is the case, but if all the circuit courts were active, that could be the other problem I see with the case, the legal system is that all of them are not basically the same way. So they need to find a way to transfer cases. For example, Nima Circuit Court and maybe Bombing or Grand Cru, they are not basically the same way.
Mm-hmm.
So they have to find a way, even if a case occurs in Nima, they need to maybe find a way to be able to send cases to courts that are less busy. Okay. So if they were to do that, some cases, but man, the problem with Liberia, people are not really thinking because they have that big man syndrome in Liberia. You know who I am, So things that affect the common people are not really interested in fast tracking it because the same idea that told Prophet Key within 48 hours, his case was judged and he was behind bar. You can also implement ideas for rape cases to be fast tracked within one term of court.
Corruption cases.
But corruption cases, you can fast track it and say, okay, since criminal code C is basic, let's send this case to River G because River G is not basic. But they're not thinking about that. They're only thinking that if it affects a big man, then obviously the law is fast. Like same for the finance minister, let him show cause why our padam not coming anymore, or let him show why our salary delay. But obviously there are so many teachers out there working with RP. There are nurses out there working with RP, and you don't summon the finance minister for that. You summon him because you have not gotten your gas slip and you have not gotten your pay on time. So it's the same process. So I don't want to believe that these cases cannot be fast tracked, but they have to come up with maybe new laws, maybe ways to transfer cases from the basic court to the less basic court. Like for example, Bapolu. I don't want to be the circuit court in Bapolu is that basic. So you could find a way to transfer.
So the conclusion here is that the court system has the power and the authority to prioritize cases if they want to, correct? But they're deliberately choosing what to prioritize in certain cases.
No, right now they may have to find. They may have to.
I mean, if they can prioritize,
if they can change, they may need to change some laws, right?
If they can prioritize a case like Perfect Key.
Yeah.
What about a family who is waiting on the ruling of their daughter being raped?
Yeah, that's what I'm saying. That the issue of cases lasting for too long is within their power. If it were of interest to them, okay, and they have what I call excess capacity because I'm saying that some courts are busy. But some courts in the hinterland and other places may not be that basic. So you could transfer cases from a basic court to a court that is not particularly basic. Maybe it may require you to change some laws on the book, but change that law and make it possible for you to transfer cases so cases can run much faster. But that's not the Liberia that I know. The Liberia that I know, there is an overwhelming concern on big people.
Correct.
Big people. Big men, big woman. That is the people the Liberian system cater to. And if you're ordinary citizen, no. Your situation is not a hurry. Go through the procedure. But when it comes to them, then the procedure must be like 5G. And 5G are the fastest now, or they got more than 5G now?
Yeah, 5G is.
Yeah, they make their things fast G, like Prophet Key now. Oh, no, we can't wait. I can't even waste time. I will not go to the civil law court because it will take too long. You're bringing here on contempt. But if like the ordinary person, they say, no, go to civil law court.
They say
Yeah.
use Lone Star.
Yeah, go to the law, go to civil law court. But if it's them, they say, no. Civil law waste time. Bring him here now. Bring him here on contempt. Day after tomorrow, bring him. Let him come now. Let Josh a case. Quick. For if you know about quick, make it quick for the ordinary citizen to benefit.
True.
Absolutely. Fast track. And speaking of fast track, to fast forward our conversation, there needs to be some type of structure and system in place for our systems to take accountability and fast forward the ordinary person, civil citizens cases, and make sure and ensure that this is actual and equal opportunity justice for all. No institution should operate without oversight. So we want to go ahead, Attorney Freeman, and talk about accountability on checks and powers, public awareness and civil participation. That's a part of accountability. A healthy democracy uses checks and balances. This is all encompassing rule of law. So our question for you is, if the Supreme Court oversteps its authority, what checks and balances or accountability exists? What role does the legislator also play in judicial accountability?
Don't give me no political question about Supreme Court overstepping the authority. Prophet Key already in jail. Prophet Key already in jail. You can't tell me about Supreme Court overstepping the authority. That sounds like a political question.
You're a lawyer, you'll be just fine.
Yeah, Prophet Key already in jail, So, but the question, let me tell you the limit on the
sure,
the Supreme Court. So now we have the national legislature. They are a political body.
Right.
If they believe that the court overstepped their authority, they can pass a new law. They can define what constitutes criminal contempt. They can define what procedure must be followed when criminal contempt occurs. They can define what the punishment is or what the range of punishment should be.
Right.
So right now, that is what they can do in order to limit the Supreme Court. Also, too, obviously, they legislate the budget. If they're not happy, obviously, they can cut certain aspects of the legislature, the judiciary budget, until the judiciary decide to cooperate with them. So there are things that they can do. But I don't want to say like they overstep the authority. I say that I disagree with them. I feel that this guy wasn't giving his due process rights. I feel that the punishment was beyond what was provided for by statute. The punishment contradict the constitutional prohibition on cruel and unusual punishment. But it really, when the Supreme Court makes a mistake, it turns political because now it is the national legislature. But when will they finish with the gas slip argument and the salary argument before and the legislative project before they talk about something beneficial to the average citizen? They're not going to have that discussion. Matter of fact, Prophet Key particularly was somebody that they also wanted to punish. He was useful to them when he directed his thing at George Weah, and they were able to succeed politically to come to power. But now that he started directing his anger at them, he's no longer useful. So they just sacrifice him, and put him behind bars, stuff like that. But let's assume if they were a much more responsible body, then they will pass a new law, and the law will properly define anything that was not clear in the Constitution or where they feel the court may have overstepped their authority. They will define the law and say, okay, this is what constitutes or criminal contempt, and this is how much what you can punish, and this is what you can do, stuff like that. But will they do it? I doubt it. So it's a very difficult thing right now, what the country faces. We just continue to advocate and to see if it will get better. But I think we are in a difficult situation, and that's why the court is supposed to be very slow to express its anger in the way they did, because it's very difficult to correct the Supreme Court, as you can see. Who's going to correct them? The only people who can change that law now is the court themselves. They have to come back and say, okay, what we did the last time, we changed our mind, we are changing it. If they don't do it, the national legislature have to do it. Minus that, I don't really see any other way of rectifying that problem. He just have to go there and face the punishment and come out and maybe find another way to solve the problem.
Yeah, Sam. You have any questions?
I do. I really do want to call an audible and um, touch on the journalist piece. Uh, in the interest of time, I don't know real quick if you had any thoughts on the amendment to the Kamara law or just the whole discussion around that. I know that there's some concern about what it could do in terms of just making it harder for journalists. If you wouldn't mind just weighing in on that real quick.
Okay, I'll be honest with you. I haven't read the law because my legal practice is mostly on the side of commercial, business, investment, financial crimes. So mostly lawyers who focus on media rights, media engagement, they might be much more familiar with it. If you something to do with investment, financial crimes, commercial, business, I might be much more occurring with it. Maybe some civil, yes, but media law is not something I'm particularly. I know that it dealt away with criminal libel, criminal slander, but the details of it, I don't really know. But speaking generally, um, the courts are generally reluctant to punish people simply for expressing your view as public officials, because a long series of Supreme Court decisions hold that the public official must be able to withstand even the worst type of criticism. So for them to find you liable, you have to prove that this person did it intentionally with the forethought that they want to damage this person. If they were just negligent, the law would not hold that person liable. And if it were like just erroneous, they will not hold that person liable. It really has to be that you were aware that the information was false and misleading, and you had a reason to take precaution and you chose not to exercise precaution. That is the prevailing law, But with the specific in the Camara law, people who do human rights and media law, they might be much more familiar with that.
Respect. Thank you.
Thank you. Let's move to the youth and civic rights and legal awareness section of this talk show. We want to bring this discussion to the young Liberians. And some of the questions that we want to ask, not just you, but the audience, is that do the Liberian youth understand their constitutional rights? Are public defendants or defenders adequately trained and resourced? And what legal protections do young activists or critics of the government have? Because these are some of the things that we have to really look at, that we want to address when we're talking about this situation or this case. Not a lot of people in Liberia actually understand their constitutional rights. Not even the people who are supposed to be actually making and enforcing the laws. And if you are making and enforcing the laws, they probably do not have the right resources. Like we were talking about how cases in certain courts are very excessive to the point where it becomes a backlog, and that issue is sustained for a longer period of time. Where you have other courts in other counties that are actually free that could be made use of, and that's where it comes to the resources being used for not just providing the right resources for lawyers, but also providing the right resources for the Liberian people. the Liberian people pay their taxes, and they should be getting their best possible lawyers or representatives to represent them in court, especially against a constitution, to show that they're not breaking any laws, and if they are breaking the laws, that they should be able to be properly prosecuted with due process, right? So those are some of the questions that I want to ask. Do you think that and this question, these questions go out to the panelists as well. Do we think that the Liberian youth actually understand their constitutional rights, and do the court system actually provide the defendants quality resources to be able to defend the Liberian citizens as well? Yeah. And I'll go to Snotty. You can go ahead and uh, start off with that, and then I'll give my answers. Yeah.
Yeah, thank you, Russ. I feel like, in a sense, most Liberian youth, they understand to a certain degree a level of their constitutional rights, their amendments, what's right and what's wrong. But I feel like there's a sense of weaponry within our system of governmental structure that opposes or turns a blind ear to the actual rights as to what's happening. When we talk about like the minor cases and the major cases, well, there's blurred lines between minor and major. So what constitutes a minor from a major, and how can that be separated? And if you know something, if you know, with all due respect, if you know your constitution, if you know your rights, if you know the whole law and formations formality of due process, who is to say what is and what isn't when that whole structure is weaponized? So I think it's not necessarily just a matter of knowing your rights or knowing your law, but to uphold the legal leaders that are responsible for the whole system, who's actually in power, asserting their, I guess you can say, their power, abusing their power, either or taking accountability for their power to actually give our citizens the right due process, the right to actually be part of our civil justice system, the right to actually seek justice and find justice. So it's a matter of, this, of course, they can understand the whole system, the legalities of the system, but then it's another thing and a totally different beast when though our leaders are turning the blind eye or weaponizing their power within those systems and those frameworks. I can say that to be legally informed, I guess our youth, to be more legally informed, there needs to be civic groups of educational products, educational groups, the ones that do know, helping, teaching. It's each one teach one, teaching the constitutional rights, teaching these articles, and giving our brother and sisters that don't necessarily know the time of the day to teach them and let them be aware of their legal rights. Because as we see right now, they did it to a famous influencer, and his due process was skewed, and it was under subjection. So if they can do it to an influencer, what makes us think that we are above the law or underneath the law? Or what makes us think that we can't be a victim as well, or our brothers and sisters can't be a victim as well? So I think that's like the misunderstanding. And in terms of reformation, accountability, checks and systems, like Attorney Freeman spoke to. If they wanted to, they could. I think it's just a level of finding accountability within themselves as leaders, seeing how they can actually listen and listen to our people, the citizens, listen to what they have to say, and taking accountability into putting those systems and frameworks and the policy and the constitution from which Liberia stands for in order. So
Thank you. Sam.
Yes, sir. Yes, sir. Man, I think that Liberia had a chance to rectify this about 22 years ago, just coming out of the Second Civil War. And I'm saying this because you can't demand or expect what you're not used to. And the rule of law, for all intents and purposes, is quite debatable if it even exists in Liberia, just from teachers not getting paid, to even people circumventing certain processes to get licenses and things like that by just paying people under the table. From just even politicians, um, thinking about, or not even thinking about, just picking and choosing what they want to take seriously. Until the rule of law applies to everybody, then people will not know what to expect in terms of, what a society looks like that adheres to the law. It has to be practiced in all forms, even down to people's ability to lay a complaint officially and get a response, very quickly. It has to be part of the daily fabric. And until that is the case, people will not understand, what it is that they're losing out. It's the very reason why people are able to laugh at Prophet Key and take joy in his pain without understanding that they will be next. And I'm very, very adamant about the media, because the media is the fourth estate. And I said it on the first program, I'll say it again. The topic matter that I've seen across the board, at least with the influencers and the videographers, other than Focus on Liberia, I'm very hard pressed to find other outlets where people are taking things very seriously. Now, the print media, it's a different story, but I know people like the visuals more. But as far as the visuals, you know, until we as a society take very seriously the law and take very seriously, building systems that are consistent, and that systems that lack bias as much as possible, then our children and our grandchildren will not know what justice looks like. Right now, it's just a free for all, and that's just very bad for everyday Liberians who want stability, and especially for those of us, in the diaspora, because some of us do want to come back, but you know, those of us who may be used to the United States or whatever else, after a couple of decades or so, coming back and investing, it might be a different thing. They might not be encouraged to do so, and that's a big thing that we got to talk about. So I'll leave it there.
Thank you. And I'll just go ahead and answer. Do the Liberian youth know their constitutional rights? I'll say maybe. Because a lot of times we do see them engaging in political conversations, but engaging in political conversations and debates or going to act protests or other activist activities. These are not really knowing your constitutional rights, right? Even people who have never picked up a book can go in the street to go and protest, right? They're aware that they have that, but to what extent? Most Liberians don't know that they can find the Liberian constitution online. They don't know that. And even these are people that have access to the internet, right? They have access to Facebook. Most Liberians don't know that they're actually paying taxes. Most Liberians don't know that they deserve due processes. Most Liberians use the law against other people because they have the resources as well too. So they know that some of the things they know that the law goes against some of the things that they do, right? And they utilize the law to actually put poor people behind bars without any due processes. So they are somewhat aware of it, but when it comes down to actually them defending themselves, I don't feel like they are very well knowledgeable of the law. And then the next question is: are public defenders adequately trained or resourced? As we have seen in the Prophet Key's situation and case here, I can argue that they are not.
No, but just to a point, the people, I don't know, I think the two lawyers, both of them were not like public defenders. Maybe one of them was, but there was another veteran lawyer. I know because he and myself worked on a case before at the civil law court. So, but
he was
it's difficult, huh?
He was given a public defender, correct?
Yes.
Okay.
But I think only one of the lawyers I know to be like with the public defender's office.
Okay.
I think there were two. The other lawyer was not a
Yeah. I'm
Public
speaking.
defender.
I'm speaking specifically for the public defender, and
Okay.
my comment on that is that we see. Can we look at the budget actually and see how much is allocated towards the court system? And it will tell you that um, we don't prioritize any legal matters. A while ago, last year, or I think earlier this year, the president was at a summit, at a UN summit, talking about, um, I believe it was women's rights, and how he was allocating, resources to providing the best women's rights, and things like that, and things of that nature. And I was like, we currently have a lot of rape cases pending. So if you are prioritizing these things, the budget should actually reflect that. And like Attorney Freeman was saying here, that we should be able to decentralize some of the courts that we have. If we notice that the courts are getting backed up, we should provide excuse me, we should provide the right resources so that these other cases can be able to at least show the country that we are allocating the time, the resources, the expertise towards these cases. And these are very detrimental cases. These are not cases of people just stealing pepper, biraba in a market. These are cases that families are being actually, emotionally or financially scarred. Um, and even as well as physically, as we can see with these rape cases of these young girls, right? Some of them will probably never be able to give birth again, and we know how severe these situations are, and we have seen videos of the little boy that was sodomized actually crying in the hospital from behind pain. These are physically damaging cases that are not being prioritized because the resources are not there, the fundings are not there, and it goes to tell you that the government, are they prioritizing some of the cases that we have on in the backlog in the justice system right now, and it goes to tell you that they're not. Um, and I'll give the floor to Attorney Freeman to comment on that. Do you think that the Liberian youth understand their constitutional rights, or public defender given the right resources? Um, and
Okay, so
lastly, what legal
I
protections?
want to,
Hold on,
I think
let me
the
just
public
complete the last.
defenders are,
Sorry.
yeah, just a point, just a point.
Okay.
I think the public defenders are trained. Um, I'm convinced that almost all of them are like certified lawyers and they have regular training. So I don't know, but I feel it's really not a lot about training as it has to do with um maybe other considerations.
Such as what?
Uh like for example, the case I said a case go to Supreme Court and they appoint you to represent somebody and you're really not committed to representing the person. You know what you're supposed to do, but you just chose, not to do it. Because when it comes to malpractice, even people who are knowledgeable can um, commit malpractice. Because what happening is that in Liberia now, they have not only the lawyers trained at the law schools, but they have judges that are trained at what we call the James A. Pierre Judicial Training Institute. So they are also trained to administer justice, mostly from the point of view of magistrates. So they are given the basics and they can do it. If they make mistake, that would be understandable because the training is not like extensive. So they are accessible. People at the Supreme Court level, if they blunder a lot more, it has to do with willingness than it has to do with um training. But the real problem in Liberia is a governance problem. Eh, and unless we solve the governance issues, it will be difficult because um, you have a legislature that spends almost like a quarter of the budget on himself
Mhm.
and without accountability. They have spent almost $1 billion without audits. And even the small audits that go on, they want to hold the justice minister in contempt for attempting to go beyond that. And if we don't structure the government in a way that the resources is provided, because if you look at it, let's take the case of the backlog of cases in some of the courts. If you're going to send somebody, like throw a case to maybe send it to maybe River G or Bapolu, you probably will have to spend more money for the case to be transferred there. If they don't have the resources to do it, they probably wouldn't be able to do it. Or if they don't have like the laws in place. So a lot of have to do with the governance structure and the lack of priority for things that should be important. We see most of the time they make all these foreign travels, they spend a lot of money. Even the amount of money they spend on
Complaining about
security, like the NSA, they spend, I check it, they have spent well around $240 million on NSA since 2006.
yes.
Yes, $240 million. Just imagine. So if you were spending that money, maybe improving the judicial system, maybe things will be much better. So a lot has to do with the governance structure. And if you don't have the right people, we will complain a lot, but it will be difficult for us to make progress, because most of the time what you see is just in the Monrovia area, but in the hinterland area it's even worse, because if things are not even functioning properly in Monrovia, you can imagine what's going on in other parts of the country. So we have a far bigger challenge. But again, the minimum can be done, that within the given resources, a minimum can be done. But are they really doing it? I have my doubts, especially with some of the judgment coming out of the courts. People are kind of discouraged because people believe some of these cases should be like more like slam dunk, but you find out that. And some of the problems is structural. Like, even though it's not something you're discussing now, but take the case of the LACC. I worked there for like 5 years. They restructured the LACC, and it went from 5 commissioners to 7 commissioners. And people say, okay, the LACC have been restructured. But the way I see it is a much bigger problem, because whereas they never had money, they now have 7 commissioners to take care of. By the time you finish taking care of 7 commissioners, you better have money for investigation. You better have money for operations. So if some corruption act is going on in Bapolu or is going on in River G, you're not even able to swiftly, arrest the situation, because obviously by the time 7 B shot they will belong to them, there's hardly anything left. And we have a lot of that around the government. Like, take the election commission, you have 7 commissioners. You don't need 7 commissioners to run an election. You also don't need 7 commissioners to run the LSCC. You need more investigators, more lawyers. So restructuring. So we are even saying don't investigate. But if you take all the money and give it to the commissioners, even if you don't tell them don't investigate, there's no way they will investigate, because they don't have that many investigators and that many lawyers. So a lot of these things that every day they make, right now they open a new ministry called Ministry of Yellow Machines. I mean, they don't call it Ministry of Yellow Machine, they call it Yellow Machine Board of Authority. But if the way they operate is like a ministry, because now they are recruiting 20 staff.
He takes the same pay as other ministers.
Fine. So you establish a Ministry of Yellow Machine, right? So now, after establishing a Ministry of Yellow Machine, even though you got public work, you got transport, you got all these people, you bring another one called Ministry of Yellow Machine. They hire 20 persons. Maybe before they finish hiring, it will be like 30 persons. By the time you finish spending all that money, now if some crowd is going on in Totota or in some far off places, how are you going to arrest the situation in the shortest possible time because, of course, the bishop already been taking all the money. So those are some of the structural issues. That's why Liberia problem is not necessarily change of party. Because if you realize, we changed from CDC, first we changed from UP to CDC. The same thing that we saw in UP for which we changed to CDC, CDC started doing the same thing. Then we said, no, the CDC people now cool. Let's change from CDC to UP. Well, the UP people came back and they're doing the same thing. For example, like in the case of the NSA, George Weah spent, in the 6 years George Weah was there, he spent almost 120 million on NSA, covert operation. And Mr. Boaka, since he came, in 2 years or in the 3 years now, he has spent like 52 million on NSA covert operation. What's the benefit? So when you spend money on covert operation, how are you now going to have the money, right, to spend on rule of law, on investigation, on stuff like that? So it's a lot more detail. I guess it's a conversation for another day, but that's what we call structural issues, which cannot be necessarily blamed on one person, but the way the system is designed to fail. Like I tell you, the LSCC is designed to fail. As long as you have 7 commissioners there, they will consume the resources. Secondly, it will be difficult for them to make decisions because that 7 persons sitting there and arguing, 7 persons is almost like a parliament. And when you're fighting crime, you can't have a parliament, everybody there, you have 7 persons arguing before they make a decision. Decision making has to be very fast. So you design a system in a way that is just not going to work. So those are some of the issues that we have. Whether these leaders that we have now have the vision to go beyond that, to make the necessary reform, that is a question. 3 years on, we will see how well they will do, but those are some of the issues. But, with respect to the maybe I'm a little biased, because being a lawyer, I will say, okay, the defense counsels are trained, so you can charge me for being biased. Yeah, but I think they are trained. I think they do take training on a regular basis, but sometimes the issue of the structure that they are operating in, sometimes the availability to resources and logistics and other things can hamper their ability to deliver what is required under their law.
So to leave us with this question, are the Liberian youth, do they understand their constitutional rights? And what will your advice be to some of the people who don't understand their constitutional rights?
Honestly, that is something that I really don't know. You probably will need to call some politician to discuss, what a Liberian youth think. yeah, man. Lawyer, our training is defective because we are trained to analyze something specific at a specific place, time, and stuff like that. That's how we train. So to just tell you, I know what to tell the Liberian youth, in terms of the constitutional rights, this and that, a politician would probably be a better place to answer that question. But if there is some specific legal issues, maybe I can address that.
Pertaining to freedom of speech and due process.
Well, the only thing I would tell them, don't go the Prophet Key route. Don't go the Prophet Key route because you could find yourself in hot water. No, but on a serious note, I think, firstly, let's just start with on an individual level. If you are taken to a court or a judicial process, you have a right to ask for postponement. Giving you sufficient time to respond to any allegation against you is one of the fundamental aspects, right? So there is no court that you can, except maybe for an active criminal act, and they are looking for you, like maybe you burglarize and the police is looking for you. Then maybe they will grab you and carry you right away. But even if they carry you to court, once you are in the jurisdiction of the court now, you have a right to ask for postponement, to prepare, to look for counsel, So you don't just go talking or saying whatever, or just take any lawyer that say, oh, my man, take me. I've been in a court for long, and everybody call me legal Maradona. Everybody know me here that they need to call me legal Maradona, so you can
They
take
go
me.
what?
So legal Maradona. So
Wow.
I mean, yeah, you have people in the court will tell you, say, oh, take me, I can be a good lawyer for you. You reserve the right to ask the judge to postpone the case so you can find a good lawyer. The other thing is, every country, not just Liberia, there is something called legal aid clinic. So those are where they have trained lawyers that are available to help people who don't have money. So whenever they take you to court and you have an issue, it's always good to ask if there are available lawyers. And you don't have to always take the first lawyer that comes your way. You can decide, if you're not sure, you can postpone. But another part of it, and maybe on the advocacy side, all this praying and fasting and waiting for God to come down to solve your problem, it's not going to work. I must say I'm a Christian and I pray to God. But there's a reason why God gave us 5 senses. And he expects that when he gave you the 5 senses and he's saying you on earth, he expects you to make use of those 5 senses. So the things that you want in Liberia, you have to advocate for it. You have to push for it.
Well, say that one more time. So we don't have to pray for things, and we have to advocate, right?
You have to advocate.
Okay.
You have to push for it. You have to work for it. You have to labor for it.
Absolutely.
Not all that thing, claim your blessing. I'm not saying that. Maybe if it's a spiritual thing, you can claim it. Spiritual. But if like something have to do with your rights, the constitution, the country, it's not something you can pray about and waiting that it will get improved. Because, for example, you have the sense, to be able to speak. So you can speak, you can use your ear, you can hear something, you can use your eye, you can read. There's a reason why God gave us 5 senses. And then after he gave it to all, he's saying you on earth. And that's the same 5 senses other people are using to build their country. They're not using anything different. They're using their brain plus the 5 senses. Mm-hmm. So too much of this claiming blessing, tarry, for the condition to improve, it's not going to work. Put yourself together. Advocate for what you want. Push for what you want. Lobby for what you want. But even me, sometimes I get family people call me and say, sometimes I talk too much, I need to slow down. And if you tell me nothing too much, sometimes I call it from you. Because it's not what I want to hear, because you're not talking. So if I am talking, at least let me talk. But you're not talking. Then I won't talk, and you say, oh, you're talking too much. So if you don't talk, I don't talk, then how is the country going to get better? No country gets better by the citizen being disengaged. And it is the youth that can lead that. You know why it's important the youth lead it? Because the older people, they have wife, they have children, they have relatives that depend on them. So anytime they're making decisions, they start to think about their wife, their husband, their children, the relative that depend on them. And sometimes when they think about all that one, they say, no, man, I will do what the people tell me to do. I'm not going to do anything different. But the youth, they don't have that kind of constraint. So they can easily make decisions and they can be like forceful because they don't have that constraint. So that is why when people are talking about advocacy for the country to change, it is really incumbent upon the youth to lead that. You see around the world, most of the political changes is coming about because the generation, I don't know how to call them, Z, right? If I mistake, correct me. Yeah. Generation Z, right? They are pushing. So you can have our Liberian youth who did it having tarry, they claiming blessing, they go to prayer mother, and and they say, oh, let wait, God will deliver. God not delivering you. God already gave you 2 hands, 2 feet, mouth, ear, eye, brain. That's what God is expecting you to use to change your country. Stop sitting down waiting for Moses to come from on the mountain with a rod, to use the rod so that all Liberia problem can disappear. No, Liberia problem will only disappear if we become active, we mobilize, and if there are things that are not correct, we push to correct it in our country. That's how the country is going to be changed.
Thank you.
So I want to say this because I know a lot of Liberian people, they would rather go to Tari and spend 3 nights and declare Holy Ghost fire and wake up 2 in the morning and bombard the devil and banish him into the sea. But to make that advocacy, to protest, to march, to say something to correct the country, they're not able to do that. But they can spend 40 days fasting. Yeah, you get spiritual enlightenment. But in terms of your employment situation, in terms of the corruption in the country, in terms of the benefit that you should get from your government, you're not going to get it by that means. You have to advocate for it and be forceful. So that much I can say. Sorry if some of you are like Pentecostal Christian, whatever, you declare Holy Ghost fire, never mind. But I mean, I see a lot of times young people will, go to prayer mother or, pray and fast and other things like that. It's not going to change the country substantially. You have to, what you want, it's like in life yourself. If you want something, you can't sit there and wait for it.
Absolutely.
You have to move forward, push, press forward, do whatever you can. So we're talking about, you want your legal rights or you want this one, you want to mobilize yourself, put yourself in group, advocate for it, write a letter, visit people, petition, protest, stuff like that. That's how it works.
Attorney Freeman. Thank you, Attorney. No, I said thank you so much, Attorney Freeman, for that. We snap and clap to that.
Yeah.
Is dead. Indeed. So there you have it, folks. To all of our listeners, to our viewers, to our Liberian youth, both in the diaspora and on the grounds. A strong democracy requires informed citizens, accountable institutions, and leaders who respect the law. And the future of Liberia depends not only on laws written in the Constitution, but also on citizens, our youth, who understand and defend them. To counter this conversation and to end it, we want to actually charge and give Liberian youth a charge. We believe that tonight's conversation reminds us that, democracy is not sustained by laws alone, but by citizens and our youth who actually understand those laws and the institutions that apply them fairly. So as we close tonight, one thing becomes clear: the rule of law is not just about courts or lawyers. It's about the everyday rights and protections that shape the lives of the citizens. So for the young people watching, the future of Liberia actually depends on a generation that understands the values, justice, and participates them actively in civic life. Let's hold our government and our leaders responsible by doing our daily work, by enlightening ourselves and encouraging our brothers and sisters to know their rights and responsibilities. I enjoyed this conversation and I hope you did too. Attorney Freeman, thank you so much for joining us. Thank you for joining us and being a part of this awesome conversation. Gentlemen, Anthony Russell, Sam, thank you so much. And this was The Rule of Law, Free Speech, and Institutional Accountability on Focus on Liberia, NextGen. Thank you so much.
Okay, thank you. Bye-bye.
Bye.